AGI Greenpac's strategic acquisition. Acquisitions represent growth and strategic maneuvering. AGI Greenpac's takeover of HNG Float Glass Limited in 2021 was significant. HNG faced financial distress, leading to insolvency proceedings. AGI Greenpac saw an opportunity to expand its market presence. The transaction faced legal hurdles due to insolvency and competition laws. This case highlights the need for a clear legal framework for complex acquisitions. The IBC, a lifeline for distressed companies. India's economic landscape has transformed with rapid industrialization and globalization. Recognizing the need for a robust framework to address corporate distress, India introduced the Insolvency and Bankruptcy Code 2016, IBC. The IBC marked a shift to a time-bound and market-driven insolvency resolution process. Its primary objective is the timely and efficient resolution of insolvency cases, maximizing the value of distressed companies' assets. The IBC introduced the concept of an insolvency professional to manage the distressed company during the resolution process. This professional, along with a committee of creditors, evaluates bids from potential investors and selects the most viable resolution plan. The IBC's focus on time-bound resolution prevents the erosion of the distressed company's value. The code has been instrumental in addressing non-performing assets in the Indian banking system. However, its implementation has also presented challenges, particularly when intersecting with competition law. The Competition Act. Ensuring a level playing field. In today's globalized economy, competition drives innovation, efficiency, and consumer welfare. To ensure fair competition and prevent monopolies, India enacted the Competition Act 2002. This legislation seeks to create a level playing field for businesses, benefiting consumers and the economy. The Competition Commission of India, CCI, enforces the Act, preventing practices that adversely affect competition. This includes anti-competitive agreements, abuse of dominant position, and regulation of combinations, mergers, acquisitions, and amalgamations. The CCI's role in merger control is crucial in preventing monopolies that could harm consumer interests. Before any significant merger or acquisition can proceed, it must be notified to the CCI for approval. The CCI assesses the potential impact on competition and can approve, modify, or reject the merger. The intersection of the Competition Act with the IBC presents unique challenges, as seen in the AGI Greenpac HNG acquisition. Navigating the crossroads, IBC and competition law in the AGI HNG deal. The AGI Greenpac HNG acquisition presented a unique scenario where the IBC and the Competition Act intersected. HNG, facing financial distress, was undergoing insolvency proceedings under the IBC. AGI Greenpac's bid to acquire HNG's assets was seen as a viable resolution plan. However, the acquisition raised competition concerns due to AGI's significant market presence. The CCI had to assess whether the economic benefits of reviving HNG outweighed the potential adverse impact on competition. The CCI recognized the unique circumstances, acknowledging the IBC's objective of resolving insolvency. It considered that HNG was unlikely to survive without the acquisition. Balancing these factors, the CCI approved the acquisition with certain conditions. This case highlighted the delicate balance between promoting competition and facilitating insolvency resolution. The AGI Greenpac HNG acquisition left several legal questions unanswered. These questions highlighted the need for greater clarity in dealing with acquisitions under the IBC. One key question was whether the CCI's jurisdiction is ousted under the IBC. Some argued that the IBC, being a special law, overrides the Competition Act, potentially hindering speedy resolution. Another question pertained to the assessment of competition in the context of insolvency. These legal ambiguities highlight the need for a nuanced approach to acquisitions under the IBC. The AGI Greenpac-hng acquisition underscored the need for greater clarity in the legal framework. To address legal ambiguities, several reforms have been proposed. One key recommendation is for the CCI to issue specific guidelines for acquisitions under the IBC. These guidelines should provide clarity on the CCI's jurisdiction, factors for assessing competition, and decision-making timelines. Clear guidelines would provide certainty to investors and creditors, encouraging greater participation in the insolvency resolution process. Another suggestion is for the CCI to adopt a more flexible approach when assessing competition in insolvency cases. Greater coordination and information sharing between the National Company Law Tribunal and the CCI is also needed. Improved coordination would streamline the approval process and avoid unnecessary delays. Shaping the future. Impact of the AGI-hng deal on the Indian economy. The AGI Greenpac-hng acquisition has broader implications for the Indian economy. It serves as a precedent for future acquisitions involving distressed companies. The case underscores the importance of the IBC in attracting investment and facilitating the revival of distressed assets. By providing a time-bound process, the IBC encourages investors to revive businesses, saving jobs and preserving productive capacity. The acquisition highlights the balance needed between promoting competition and facilitating insolvency resolution. Striking this balance is essential for fostering a competitive and vibrant economy. The lessons from this case have prompted calls for greater clarity and a more nuanced approach to balancing the IBC and the Competition Act. A balancing act. Striking a balance between revival and competition. The AGI Greenpac-hng acquisition highlighted the tension between reviving distressed companies and maintaining a competitive market. The IBC aims to maximize the value of distressed assets and facilitate revival. This often involves attracting investors who can inject capital and expertise. However, such acquisitions could lead to reduced competition. The Competition Act seeks to prevent practices that harm competition, including mergers that create monopolies. The challenge lies in balancing these objectives. A nuanced approach is needed to ensure both revival and competition are maintained. Global parallels. Lessons from international jurisdictions. The challenges posed by the intersection of insolvency and competition law are not unique to India. Several jurisdictions have grappled with similar issues, offering valuable lessons. The European Union has a flexible approach in insolvency cases, sometimes approving mergers to prevent liquidation. The United States has guidelines for analyzing mergers in the context of bankruptcy, considering the failing firm defense. Learning from these experiences, India can refine its legal framework. A balanced approach to acquisitions under the IBC is essential. Conclusion. Towards a more robust framework for acquisitions. The AGI Greenpac-hng acquisition highlights the complexities at the intersection of insolvency and competition law. While the acquisition resolved the distressed company, it exposed the need for a more robust legal framework. The IBC has shifted India's approach to insolvency resolution, but its interaction with other laws requires careful consideration. Each case must be evaluated on its own merits, considering the unique circumstances and potential impact on competition. Reforms, including clearer guidelines from the CCI and greater coordination with the NCLT, are steps in the right direction. By implementing these reforms, India can create a more predictable and efficient legal framework. The AGI Greenpac-hng acquisition offers valuable lessons for policymakers, regulators and businesses, fostering economic growth and protecting consumer welfare.